Good afternoon, everybody. Welcome to our UCCJE webinar. Today is March 3rd, 2022. Spring is right around the corner. I'm Lisa Speaker, and today I have with me Matt DeLange. We were supposed to have a couple of other special guests, but both of them got ill. The good news is people aren't getting sick with COVID anymore, so I'm really happy that we're just getting our normal springtime illnesses. We hope that Kyle and Caitlin feel better soon. But the great news for you is that Matt is the guy. He's doing a lot of UCCJ work and is kind of like the main person in town now that Jean Hanna's retired. So, and when I say in town, I mean in the state of Michigan. So for those of you who don't know Matt DeLange, he is a private practitioner in Grand Rapids. His law firm is called the Michigan Family Law Center, and he's a full-time family law attorney, but he's really developed the specialty around the UCCJAA cases. And Matt, do you also do Hague cases?
I do Hague, and I do quite a bit of UIFSA cases as well.
Say the last one.
UIFSA?
Oh, UIFSA, of course. Okay. And that's another reason to have your blue book handy, as you do, just in case you're in federal court dealing with an interstate case. So welcome, Matt. We're so glad to have you here. Now, I know people in the audience will have questions. I think this is a very, the UCCJ is a very dense topic, so don't hesitate if you have a question. You can put it in chat, or you can put it in the Q&A function. We'll do our best to get to all the questions. And if we don't, I'll save them so that we can have a chance to communicate with you privately if it's just something that we cannot handle on the fly here today. So I just wanted to, like, by way of introduction, I'm a family law appellate specialist. I deal with complex statutes all the time. This is a really complex statute. I mean, it's not that big, but I find it, even as many UCCJ appeals as we have done in this office, every time we have one, I really feel like we have to dig in and relearn it because I feel it's really complex, and maybe Matt will shine a little light on it today. I'm not going to ask for a miracle, but he does have a really fabulous flow chart, which I think he's going to allow me to circulate after this. That will help attorneys figure out where they are in the process for UCCJ cases. So don't feel bad if you feel a little bit overwhelmed by the UCCJ, because it's not easy stuff, I don't think. Anyway, so I guess welcome, Matt.
Thank you.
I don't know if you have any introductory cautionary notes, or if you just want me to start launching into questions for you.
Well, let's just kind of dive in. My thought would be, let's just kind of start with what do you do when you have a case just at the beginning? So you have an incoming call coming in. What kind of things do you want to look for? Some of the key things to pay attention to is there a prior existing case anywhere? Is this a post-judgment modification? Have the parties lived out of state at any point in time? And if they have, start going through your kind of timeline with them. As you guys know, you have to file your UCCJEA affidavit anyways as part of the court. So keeping that as part of your intake part keeps you on track, because that goes to the jurisdiction of the court. So you want to catch this right at the beginning versus getting part of the way through, learning about it, and then having to start all over again. Another key part too is with UCCJEA jurisdiction, it looks at the time of filing. So it deals with whether or not there was proper jurisdiction at the time you filed, not at the time that the court makes its ultimate determination, which can cause issues at times. So I've seen people who will go and file a DC case prior to filing a custody case here, but it may be at the time that they filed their DC case that the children may not have been in the state of Michigan for 6 months yet. And if the other parent still remains in the other state, that state's going to have home state jurisdiction for at least 6 months as the left behind parent there.
So, Jean Hanna always used to tell me that building the chronology, building the timeline is the most important thing you can do in a UCCJ case. Can you just talk a little bit about that? Are we talking about like the facts of on the ground of what the parties were doing in their lives? Are we talking about the procedural facts? Tell us about that timeline that helps you as an attorney pursuing a UCCJ case to understand what's going on?
Well, part of it is we have the case of Rothmuthi came out, I think in 2018, and that really kind of set the groundwork for what you need to look for. So under Rothmuthi, it says that you look at the physical location of the children, not necessarily the domicile of the children. In doing so, you need to look at where they're actually at. I've had a few cases where the parties were extraordinarily transient. where they were living out of a RV and living state to state. In that particular case that I'm thinking of, the other side was trying to argue that the parties were domiciled in Michigan because that was the last time that they had actually all lived in a real house versus their RV that they were living state to state. So like in that case, because Rothmuthi came out, it was very clear that it was the location of where the children are reside that you look at versus their legal residence.
Well, that actually makes me ask a question, because there's a couple of places in the UCCJ where it talks about physical presence not being required. Is that regarding a different section, or like how do we deal with the intersection of those two ideas?
Right, so that part about physical presence, unlike UISFA, where you have to have personal jurisdiction in order to handle the case, under the UCCJEA, it's looking at the in rem jurisdiction of the court. And yes, while it does say that you're looking at section 201 subpart E that talks about physical presence of or personal jurisdiction over a party or child, not necessary, which is absolutely true, but you still have to go within your like your test dealing with where the home state is at, whether or not there's a left behind parent. So that what the part that is often overlooked, well, we're kind of jumping around here, but yeah, physical presence is not required. In part, you're looking at, there's protections in the UCCJEA to protect the left behind parent. And as part of that, if you go into section 201(1)A, which we normally refer to as the home state jurisdiction, there's really two categories of home state jurisdiction. There's the traditional one where everyone's still present in the state and the children have been here for 6 months. However, the other category of home state jurisdiction under 1A is when, say, the other parent and the child leave the state. If that state was the child's home state within 6 months of the time of filing, you still have your home state jurisdiction in the state of Michigan under 1A, which is really a key thing to do. So if someone's running off with a child, it's really important to file that within the first 6 months.
It does not defeat home state jurisdiction, but you've got to get to court. You've got to hire your attorney quickly enough to get something filed in that before the 6 months have passed, right?
Yeah, once it hits 6 months, if the kid was in one particular state, that state's now going to have home state. You do not file it within that 6 months.
You made a comment earlier, and I just wanted to highlight it because it was a really a significant point that you were making, is that just because there's jurisdiction for support under UIFSA, that does not mean there's jurisdiction over the child for purposes of custody and parenting time. And that means you could have battles in two different, and I've had clients with battles in two different states, one based on child support and another state for child custody and parenting time. So don't be surprised by that, just like Matt pointed out. So,
and one key thing to look at that as well is, because especially when you have separations, like I have a fair amount of military clients where they're separating, and one of the parties will want to leave and go back to where their family support is at, so they'll go move there with the children. And part of it is looking at whether or not the out-of-state parent had ever lived in the state of Michigan or anything like that. As you may have a situation where, particularly if she gets up here with the children, stays here for 6 months, if the out-of-state parent had never lived with the minor children in the state of Michigan, it's very likely that state of Michigan would not have UISFA jurisdiction over him, but would have UCCJEA jurisdiction over him. But unlike the UCCJEA, UISFA is waivable. It is not a subject matter jurisdiction provision for the most part. So as such, under UISFA, they could say, let's say the child support guidelines are better in Michigan than they were, say, in North Carolina. If you're representing the North Carolina attorney or client, you may want to look to see which state has the better guidelines for your particular client. And if Michigan's better, then just waiving that particular issue.
So you made a comment about a scenario where the parties did not live together in Michigan with the children. It was the children came to Michigan with one of the parents, separately. So Michigan would still have jurisdiction over that parent that's in another state, even though that parent doesn't ever come to Michigan, doesn't exercise parenting time in Michigan. It's not about where the parent is, it's about where the children are. Is that correct?
Yes, so it looks at it regarding the court's in rem jurisdiction over the minor children.
Got it. Okay, if you don't mind touching on a little bit about getting that initial custody order, and I know you'll probably want to mention the Foster versus Wolkowitz case as part of that. And I'm answering a couple questions on the chat for people while you're doing that.
Yeah, so if there's never been a custody case in any state, and your child lived here, sorry, there's never been a custody order in another state. There had been some question of whether or not a affidavit of parentage would count as an initial custody determination. And the answer is that it does not.
Do you know if other states have? I mean, that was a Michigan Supreme Court decision. Do we know if other states view it the same way? Are we consistent with how other states handle that affidavit of parentage?
I believe it is. I believe there's a companion case to that one out of the Illinois appellate courts. I think in that one they summarized some of the positions in the other states, which when you're dealing with appellate stuff on the UCC JEA stuff, you remember it deals with the subject matter jurisdiction of the court, and if you do it in the wrong venue, the end result, as you can see in that case, is it's more or less you start all over again because it vacates all prior orders, as all of the prior orders up to that point in time would have been entered without subject matter jurisdiction.
Okay. Okay, so establishing that initial custody order, there's one basis is the home state jurisdiction of the children. The children have been here for 6 months. What if it's a newborn?
Right. So that can come up quite a bit. So let me give you a scenario. So let's say the parties are married, everyone's living in Michigan. The wife is currently pregnant, and she goes down to Florida to go stay with her parents. And let's say she brings the other 2 children with her. So now we have the father up here in Michigan. We have the mother with 2 children down in Florida, and she's currently pregnant. Right after she leaves, father files for divorce in Michigan. He does it within 6 months of her leaving. So now we have a situation here where the Michigan court will have jurisdiction under home state because it would have section 201(1)(a) jurisdiction over the 2 children that are in Florida, as Michigan was the home state within 6 months of filing. However, when the mother gives birth, if she gives birth in Florida, Michigan would not have subject matter jurisdiction over that child that is now born in the state of Florida, because the UCCJEA applies individually to each child regarding jurisdiction.
So are the parents going to have to pursue 2 different custody cases, one in each state?
So this goes down to what place has the authority to waive forum nonconvenience to another state. So the proper procedure here would be to file another custody case in Florida and then ask them to waive for forum nonconvenience up to the state of Michigan.
And that would require I believe, tell me if I'm wrong, that would require the 2 states to communicate with each other to make sure that everybody agrees that it makes more sense for the case to be in Michigan, because in that factual scenario, 2 of the kids did have home state jurisdiction in Michigan.
Kind of in part. So here you're talking, it's going to be, once you file down in Florida regarding the custody of that child, you're going to seek, or have the attorney down there seek to have that place waive jurisdiction up to the state of Michigan under section 207 for forum nonconvenience, but it does not, section 207 does not on its face require the 2 courts to communicate. They can, it's permitted.
There's other sections that require it, just not 207. Okay.
So okay. Section 206 is where it's required, but here it wouldn't actually technically be a simultaneous proceeding over the same child as the other court would have pled it in at the time. So here the courts may, and actually probably likely would in this particular circumstance. Yeah, so once you file down in Florida, they would file a motion simultaneously with that, asking for the court there to waive it, or you as it notes under section 207(1), you could theoretically file it there, and then in the Michigan court, file a motion to ask the Michigan court to request the Florida court to waive it up here for forum nonconvenience. As you note under section 207 subpart 1, the issue of a forum nonconvenience can be raised on the request of another court. So you could always file a motion in Michigan asking the Florida court to find forum nonconvenience up here, so you get all the kids in the same particular court.
But the bottom line is somebody's going to have to file, there's going to have to be suits for even on a temporary basis in 2 different forums until
And
that.
that's where it gets messy on this, is because it goes to subject matter jurisdiction. Subject matter jurisdiction
Can't be
is not
waived.
waivable. It can't be stipulated to.
Okay. I think Greg is sharing, I don't know if you can see the chat, but Greg Crockett's sharing a scenario. And I'll just go ahead and read it to see if you have any comment, Matt. Michigan issued the first order and Ohio court issued a different order in violation of the UCCJ and then filed an arrest warrant for the Michigan client. Ooh, it was resolved by the Ohio Court of Appeals, but my client was jailed before that happened. And Greg, I've had cases where there's appeals happening in 2 different states. It's a mess. And Matt, you and I talked about that case the other day. It was a giant mess. Ohio prosecutor's office had no knowledge of the act and did not want to know. Yeah, of course not. Okay. And then the Ohio Court of Appeals reversed. But then, yeah, okay, well, great. How do you get your client's life back after they've been sitting in jail for how many ever days that appeal took? Very interesting scenario, Greg. And I think it's actually probably happens more like, because I've seen situations like that where one party is being held in contempt by another court, and there's a dispute over which state is supposed to have jurisdiction.
I have a situation like that right now that I'm
There
currently.
There you go.
Court. So my suggestion, if that ever happens, where like in the situation I'm trying to address now, a court down south didn't have home state jurisdiction, and the minor children were not physically present in the state at the time that it issued its order. It issued a temporary emergency order. However, I'll talk about it in more detail, but that particular one requires the minor children to be physically present in the state in order to exercise temporary emergency jurisdiction. So they issued that, and then they subsequently, the prosecutor's office, because he didn't return the children pursuant to that order, issued a bench warrant or issued a warrant for his arrest, and we're trying to seek to have him extradited. So right now we are working on filing a motion in a custody case that we started up here, asking this court more or less to collaterally vacate the other state's order as being issued without proper jurisdiction. And I will point out there's one case that actually kind of has a good kind of outline for bringing collateral challenges in UCCJEA cases. That would be Hoffaker v. Hoffaker, and it's
which one? What is it called again?
Yeah, Hoffaker, Huffaker.
Okay.
And that would be docket number from the Court of Appeals 313392. It's an unpublished 2013 case, but in that particular one, it goes into the issue of the authority to collaterally challenge other orders. In that particular one, the circuit court collaterally vacated a guardianship order that was also issued without UCCJEA jurisdiction.
Oh, that's the guardianship case that we were talking about.
Well, it was a DC case, but they recognized that neither the circuit court nor the guardianship case had jurisdiction over the children in this particular matter, and that court vacated both.
And that actually leads to a point that I thought we'd make a little bit later, but it really fits in nicely here. The point that you made to me privately, that we can't forget that the UCCJEA applies to guardianship and abuse and neglect cases. And so, like, for example, there was a case that we helped out with way late in the case. A mother's rights had been terminated. The child had been abandoned in Michigan, but the mother was living in New York, and she came to Michigan, abandoned the child. So there was a child welfare proceeding occurring in Michigan. Michigan terminates parental rights, and eventually it makes its way to the Supreme Court. And I didn't know about the case until after the Supreme Court decision. But basically, the Supreme Court reverses the termination order and remands it to Wayne County with instructions that they send the case, transfer it to New York, basically to give New York a chance to decide whether it wanted to exercise jurisdiction. Now, arguably, if New York said, no, I'm not interested in exercising jurisdiction, then it would be sent back to Michigan, and I would think that termination order would still remain in effect for a child that had never been to the state of New York. I don't know. Like I said, we are very loosely involved very late in the case, but it's really important to know, and I don't know that CPS workers really understand the UCCJ. I mean, that's not a slight on that, because this is not something that I think they would have to deal with very often. And I think you've worked on cases where a child was abandoned, or you're aware of cases where children were abandoned in Michigan, and that was the reason why CPS got involved. I don't know if you have any more comments about that.
I do. So I don't typically do abuse neglect cases, but I've brought 4 or 5 collateral challenges in abuse neglect cases where I've come in for the sole purpose of challenging that court's jurisdiction to hear it. And it happens more often than you think. And to be honest, every time I've ever brought the issue of UCCJEA jurisdiction into a abuse neglect case, every time I've had the court push back or have the guardian items or CPS push back, so they've never heard of the UCCJEA being applied to abuse neglect cases. If you actually pull up like the bench book on it, it does mention it. However, it gives 2 paragraphs of references to it, noting that it applies.
In a 500-page book.
Yes.
Yeah.
And part of it is, usually when you get in the issue of abuse neglect, you're going to have temporary emergency jurisdiction. You're going to have the authority to make the knee-jerk response code deal with the emergency. And this is a case where if there is another state that has a prior custody order. Now, this is where some people get confused. So sometimes they think, well, it would only be an issue if there was a abuse neglect proceeding in another state. But that's not the case. It's any child custody determination, and that term is defined broadly in the UCCJEA. It's defined to include more or less any type of court order that deals with the authority to have possession of the child. So like in an abuse neglect case, it gives you the authority to assign who has possession of the child, who has the authority over the child. That would be a child custody order under the UCCJEA under its scope of authority. So guardianship cases, abuse neglect, parental right terminations. It does not cover adoptions, but you may have some overlap within that when you have the issue of parental right termination in order to make the child eligible to be adopted.
Well, this leads to me a whole bunch of questions, and I don't want to go too deep in the weeds, but I could envision a scenario where a family's on vacation in another state, and then there's allegations of abuse and neglect occurring in that other state. Maybe there was an incident at the truck stop or something. So that other state could then potentially take temporary emergency jurisdiction without knowing what the heck is going on in Michigan. But then, and we're going to talk more about temporary emergency jurisdiction later, but then the 2 states have to talk to each other, right?
Yeah, but you got to remember too, there's 2 categories here where it kind of comes into play on abuse neglect cases. So you have the one case where there's a prior custody order somewhere else. It could be abuse neglect, a guardianship case, or a regular custody case. So you may have one where, actually, let me give you a good scenario here that I think comes up more. So let's say the parties are divorced out of the state of Arizona, and the custodial parent in that particular case lives in the state of Michigan. So the state of Michigan is the home state of the children. However, Arizona has continuing exclusive jurisdiction over the minor children. So in this circumstance, let's say the mother's running a meth house and CPS gets involved and they bring a abuse neglect petition due to the mother running that meth house in the state of Michigan. Now, Michigan would have the authority to issue a temporary emergency order, but unless the state of Arizona waives jurisdiction to the state of Michigan, Michigan's CPS case will not be able to go to a final order. It can only issue a temporary order. And even there, it has to set a time for, it can only make it long enough in order for a remedy to be sought in the state with the appropriate jurisdiction.
So the point being, a temporary jurisdiction is supposed to be temporary,
Yes.
right?
Mhm. But I think that's an area that gets often overlooked, is they don't think about the existence of out-of-state divorce orders, especially if there's a parent remaining there.
So and one of the cases, and I started digging out like cases that we'd worked on. I couldn't remember all of them, but like some of them I had to go reread the briefs from, like, oh, now I remember what this is about. But there was a case where there was a temporary emergency jurisdiction order out of another state, but then the kids and one of the parents had moved to Michigan. So everybody agreed that Michigan had jurisdiction at that point because they had been here for more than 6 months. But the judge in Michigan basically kept the temporary order in place, the decision that, you know, awarded custody and parenting time to one of the parents, the one that came to Michigan, without like having an evidentiary hearing, without making any findings. It was basically just adopting the temporary order. And thankfully the Court of Appeals reversed that. But it's like that, I think that goes to your point about how it can be confused when there's a temporary order. What does that really mean from this temporary order from another state? Now, we do have a couple of questions. The first one's more of an international question, but I think I know the answer. So I'm guessing I kind of want to see if you're on the same page with me. There was a question about the Department of State helping out with an international case. And the concern was because this attorney had problems getting help from the Department of State, but it was in a war zone. And he wanted to know if it made a difference if it was like, France or the UK. And I'm thinking it makes a difference if it's a Hague case or a Hague country or not. Like, you're going to get help from the State Department if it's a Hague country. That's my instinct. What do you have to say, Matt?
You get some, because I've done a handful of Hague cases, and I get them through the State Department. And I mean, they give you some assistance. So they give you like translation services. So they'll assist you in trying to do those communications. They'll assist you in communicating with the government of the other country. They'll assist you in trying to get documents back and forth between courts there and courts here. But they don't, unless you're like a real high profile case, they don't give you a whole lot of assistance. The best source for a lot of assistance in dealing with like international cases or even interstate cases where you're trying to get the children back would be like if you go to missingkids.org,
right.
The National Center for Missing Exploited Children actually has a whole division that just handles like family takings. And surprisingly, if you have a low income client who can't afford to come back up here to get the children, they will actually assist in getting airfare travel pro bono to get the kids back to the appropriate state.
Do they help with an attorney in the other state if they need to have an attorney in 2 states?
No, they won't pay for it, but they may assist you in locating one.
Okay, fair enough. Okay, so I think we sort of talked about this before. We danced around a little bit, but I think that the reason there's a question because we didn't really hit the nail on the head. What does it take to get jurisdiction over a child who's not 6 months old? Is it where the child happens to be located?
No, it's where the child was born. Well, it's where the child was born, so long as a parent remains in that state. If no one remains in that state, then likely the child has no home state jurisdiction. You're going to have to go down kind of your decision tree regarding the appropriate venue at that point.
Okay, so the scenario that is being shared with us on the chat, and I think I know the reason for the answer, is the child was born, mother lived in Michigan at the time of birth, and then 2 months later they moved, and then dad filed, they moved to another state and dad filed in Michigan. But the child and the mother and the child were gone. So they shouldn't have been able to file in Michigan.
Right,
if there was no.
If the child was, okay, so if the father, okay, in this case, if the father.
I'm reading it to me that she and the child moved 2 months later. If the child stayed with the father, then clearly Michigan would have jurisdiction, right? But
even if the child, so long as the parent remains, so like in this particular situation, because it was the home state of the minor child within 6 months, so between birth,
it was the home state, even though it was less than 6 months because the child was a newborn.
Yep, because you look to see, was
Uh.
Michigan the home state within 6 months of the filing? And the answer is
Okay.
yes, because the
Mhm.
mother was, for that period of time, it was the home state. So there was a home state within 6 months of the filing. So yeah, Michigan would still be the proper venue.
Interesting. Oh, and then you earlier had mentioned an example where there's a transient family, and I've had that case too, where the family was moving around so much they hadn't been in a state for 6 months.
Mhm.
What do we do then? Do we
So then
have-
you may have, depending on if they haven't been in a state for 6 months and they've been rather transitory, you're not going to have a home state. And it's not that uncommon for there to be no home state. Because then you're going to get into the second section there, which goes to the substantial connection jurisdiction over the minor
Okay.
child.
And what is that section?
And that comes into play. So that's 102. Sorry, 201.
Yeah,
1B.
201B. Yeah, okay.
Yep. So that one applies when there's no jurisdiction under subsection A in another state, or the child's home state waives jurisdiction to the state of Michigan. And under this particular one, in order to exercise jurisdiction under that, you need to have the court make its finding that there is no other state that could exercise home state or the left behind home state. So make sure you cover both bases. Make sure that there is no place that can be called home state, and that there's no place that was the child's home state within 6 months with a parent still remaining there. If that's the case, then you can look at subsection B, and you look here to see if the child and at least one parent has a significant connection with this state other than mere physical presence, and that there's substantial evidence available in the state concerning the child's care, protection, and personal relationships. I'll say this, the Michigan Court of Appeals cases coming down under this part have been taking a very broad view of substantial connections. Yes, I think we're more in the minority. A lot of other states have been more picky regarding substantial connections than the state of Michigan has been.
Can you give an example of, not a case example, but like
Well,
they
I'll
were?
give you the example of which I thought was particularly broad, which would be the Hernandez case.
That's a published case, and we'll share the Hernandez versus Mayoral. That one?
And actually, that's one that I happen to have worked on at the trial court level. I don't necessarily agree with the appeal, but she couldn't retain me to do the appellate work on there and didn't participate in it. So that's what you get on it. But in that particular case, the minor child, I believe, was 3. And for a year and a half prior to that filing, the minor child had been residing in Mexico with the maternal grandmother. And that particular one, the Court of Appeals, on the limited trial record it had, found that the minor child there would have had a substantial connection since both parents were in the state of Michigan, and the child had been here for its first year and a half of life, even though the child was 3 and probably wouldn't remember anything here. But they said that was enough for significant connection to this state, which personally feels like a little bit of a stretch regarding it. But nevertheless, that was where they came down on it, which if you're trying to get substantial connection here in Michigan, I would compare your facts to that, as that is rather tenuous facts there that was enough for the court to unilaterally do it at the appellate level without that being a finding of the trial court.
Right. Well, that's interesting. So I know there's defenses in the Hague Convention to the application of the Hague rules. So a similar question here under the UCCJ, are there defenses to the application of the UCCJ rules? For example, if there's domestic violence, if there's a reason a parent is fleeing the state with the child, is there a way to get around the home state jurisdiction? Or is that when the temporary emergency jurisdiction application goes into play?
Well, here, so I do a fair amount of Hague cases. Almost whenever I do a Hague, I almost always try to do a UCCJEA claim together with it. I bring both simultaneous with each other, in part because
In the federal court?
you can't bring, if I do that, bring the UCCJE into it, I can't go into the federal court.
Okay,
I'll be a
so
federal abstention. They won't.
so
take,
you've been doing the Hague cases, those Hague cases you've been doing in state court rather
I
than
have.
federal court? Okay,
I've
got
done
it.
a couple of federal court, but to be honest, federal court is the federal court, and it is, they don't do these matters often, so it's an extreme learning curve, and procedurally,
Mhm.
Hague cases operate so far to left field from the way they normally run there that it can be done, and they will work, but it is, they have to kind of develop their own procedures as you go along while you're dealing with it, which is not the easiest thing. But let's go into this. So so the defenses you would find are dealing with enforcement. There's not really defenses. Well, I take that back. There is kind of a defense. So you have the forum nonconvenience, and then you also have the unjustifiable conduct of the parties under Section 208. Section 208, to be honest, does not come up very often. And even in the official commentary for that particular provision, it notes that it will likely rarely apply.
So but that could include unjustifiable conduct, could include domestic abuse, arguably.
Good.
Okay.
Yep, so the way that it goes there is you're asking the court to waive the jurisdiction here. So it's got to be, you have to bring a Section 208 claim in the court that would otherwise normally have jurisdiction. So you can't, let's say you want let's say there's cases filed in Michigan and Illinois. And let's say the parent did something really terrible to get the case in Illinois, or to try to get jurisdiction in Illinois. You can't argue that the case should be in Michigan, arguing Section 208 in the Michigan court. It has to be argued in the court that you're looking to seek to waive jurisdiction from.
Got it. And I'm looking at the language of the UCCJA for Section 208 regarding unjustifiable conduct. That gives Michigan the ability to decline jurisdiction because of the unjustifiable conduct of the parent who's in Michigan. But that, if it's the converse, where the unjustifiable conduct happened at the other end, we can't say that on behalf of Illinois. Illinois has to say it for itself, right?
And I see this a lot. It is very common for me to have people get this one backwards and try bringing a Section 208 claim against me. And I have to keep like, look, you can't do that. You have to go to the other place if you want to argue this.
Right. Okay. Yeah, I think I've seen the same thing too, Matt. So that's really helpful to understand that. What else do we need to address on the initial custody order? Did I ask the question about the?
Well, let me point this out on initial custody. And trying to determine jurisdiction as well, I should point out that other countries are treated as states under the UCCJEA.
Good point. Yeah.
So let's say you have the parties, let's say the parties were all living in Canada, mom and the kids come over to the United States and then file a complaint for custody or parenting time over here. In that particular circumstance, unless they've been here for at least 6 months, Canada is going to have jurisdiction over there. And if it's been under, well, the other thing you have to kind of look at that's a bit messy is, particularly if you're dealing with foreign, you have the UCCJE and you also have the Hague. So if it's been less than a year that they've been over here, you may have a possible issue of a Hague case from Canada coming in, as until they've been here for over a year, it's likely that Canada is the country of habitual residence for the minor children.
Okay, I do have another question, and I think we might have danced around it earlier, but if both parents file in different states really in close to the same time, is that where the chronology comes in? We have to figure out where the child was when?
Yeah, so let's go over that situation, because this is where I think Section 206 is probably one of the most complicated sections that comes into play. And here you kind of almost have to go through your flow chart, because there's times that first to file matters, and there's times that first to file does not.
Okay.
So one of the key things to remember when you're starting to go through your analysis rabbit hole is to first look to see what place was filed at first.
Mhm.
And then looking to determine what place makes the initial call, you need to look to see, was the case in the other state filed in substantial conformity with the UCC JEA? So
I'm
for
gonna share
example,
your, I'm gonna share your chart. Oops, that was not it. Okay, stop share. I thought I clicked on it, screen two. You keep on talking. It's not working. Okay. I keep on clicking on the right thing. It's not listening to me.
you know what, I got it, so I'll pop it up here.
I don't know. That's weird. Okay, go ahead.
We'll turn it on mine.
This
Does that come up for you
is,
guys?
yeah, but I'm not, this is not the simultaneous proceedings chart. Is it?
Well, so that kind of comes here for my first part of my flow chart.
Okay.
Is there proceeding, is there pending child custody proceeding in another state involving that child? If the answer is yes, you go to my simultaneous proceedings chart here.
Got it.
So now you first look to see, does that other state have jurisdiction of substantial conformity with the UCC JEA? And the important part, the reason why you look at this part to decide kind of where you need to have the determination at is, let's say Michigan has home state jurisdiction. It had been, the children had been living here primarily until 5 months ago when the mother went to Illinois. And then she went ahead and filed for custody in Illinois before the father filed for custody here in Michigan. So in this circumstance, the Illinois court would have been where the case was filed at first. However, in this circumstance, Illinois would be unable to factually exercise jurisdiction in substantial conformity with the UCC JEA because Michigan would be the home state of the minor children. So in this particular circumstance, you actually would kick you out of the simultaneous proceeding. The rules regarding contact or working between states, at least regarding the state of Michigan, applies when there is another state that's exercising or attempting to exercise jurisdiction in substantial conformity with the UCC JEA. So while in this circumstance, the Michigan court could talk to the other state because it's always permitted to do so, but it would not actually be required to do so because in this circumstance, the other state would not be exercising jurisdiction in substantial conformity. Now, let's say it's different. So let's say there's a circumstance where neither Michigan nor Illinois have home state jurisdiction over the minor children. In such a circumstance as that, your analysis chart here definitely applies. So section 206, because both states could theoretically be exercising jurisdiction of substantial conformity. It will be go to the state that was first to file will be the one taking the lead in this particular analysis.
Okay.
So let's say here, Michigan was the second one. In section 206, the way it actually ends up working is Michigan would need to stay its proceedings, and then it would communicate with the court of the other state. If the court, like so here, like in my chart here.
Which, oh, right there. Okay.
Yep. So here, the answer is yes, the other state has jurisdiction because neither place has home state.
Okay.
Then you go here, except in relation to emergency orders, the court must stay its proceeding and communicate with the other court. The other court, then the question is, and it's for the other court, that's why I have it in orange, for a matter decided by the other court. Does the other court find that Michigan is a more appropriate forum to hear the matter? So is it going to waive jurisdiction up here under section 207 or 208 up to Michigan? If it does, then we can go through our ordinary chart and determining a initial order. If it does not, as the statute says, section 206, unless the other court waives jurisdiction here, Michigan must dismiss the matter for lack of jurisdiction. One kind of caveat here too is, let's say the other court is just very non-responsive or refuses to answer. Well, then that court hasn't waived it up here and Michigan still would have to dismiss in that case. This is
Really?
affirmative waiver to this state.
So the other courts' failure to respond to the communication or the invitation to communicate means
They're
Michigan
not, they
loses jurisdiction.
may, but they are not required to communicate back. So we are required to communicate with them. There's no
Okay.
positive requirement for them to do the same.
Well, let's talk for a minute about what that communication might look like, because that's not something that I don't think attorneys are invited to, although there might be an opportunity for an attorney to be part of that conversation, but it's a conversation happening between two judges. It needs to be recorded under, what is it, 10,
I think it's
what was it?
110.
110, and we actually had a reversal on appeal when that communication did not happen, which is really a shame. Like, it's like something that's required by the statute, yet it doesn't happen, and then it's reversed on appeal. Like, why do the families have to go through that just to get the two judges to talk to each other? Okay, so let's talk about what that conversation or communication looks like if they do actually communicate.
Yeah, and that's where it gets a bit messy in part, because my experience has been that you may get I think if it's one way you're trying to get the other state to waive jurisdiction up here, or vice versa, is trying to get the courts to hear evidence regarding it versus trying to make a determination off of the sheer pleading. I mean, sometimes it could be enough, but if you look at section MCL 722.1110, that's the section that governs it all. And as part of it, if you look at subsection 2, it goes in and says the court may allow the parties to participate in the communication. If the parties are not able to participate in the communication, the parties shall be given the opportunity to present facts and legal arguments before a decision on jurisdiction is made. And I think the important part is there, particularly if it's very fact intensive, is insisting that you be allowed to present facts to the court, that the court actually be able to take testimony, or at least allow each side to proffer affidavits regarding the particular parts on there. So you actually have a factual determination regarding what state it should be in and the appropriate venue.
So according to what the statute says, there has to be some record of it, but doesn't mean it has to be, it could be a memo, right? A judge writes a memo. It doesn't have to be a recording. I mean, have you ever been able to participate in one of these communications?
I have actually. I've done it
okay.
twice now since COVID's happened, and a lot of courts are using Zoom. And I think that's helped on making it more likely to be able to do so.
Oh, excellent. Tell us all. Like, it's fascinating. I've never been able to sit on one of those.
Yeah, so I had one where we actually ran a joint evidentiary hearing between Michigan and North Carolina. It was out of the Oceana County Circuit Court and their court there, where we had both judges present. In there, we had to have some arguments regarding which judge actually was permitted to make the actual factual determination. And this particular one was very messy, as in one court had jurisdiction over one child, one court had jurisdiction over the other child. And the arguments were regarding which state should proceed to determine custody for both. So both of them actually, we ran the joint hearing in part to come up with a temporary order, because it was a factual mess with some of the jurisdictional parts. And both judges agreed it was important to get a temporary order in place to some extent. So they heard some arguments, and the judges agreed on an interim temporary order that both courts adopted, knowing that one of the two of them was going to be invalid, but they wanted to have something in place, which is creative. But then, yeah, like I said, we did that joint hearing on it. And part of it, kind of the mechanism for this, kind of goes into section MCL 722.1111, which I think is a section that is very rarely used, which talks about cooperation between courts and facilitating the collection of evidence or testimony between places. It allows a court to even request another court to gather evidence for it, or to do an investigation, or to take testimony regarding something. So that's in part what kind of the mechanism we used to facilitate that when we were looking to actually admit evidence between both proceedings at the same time. But that one, ultimately, they reached an agreement which court was going to have to make the factual determination regarding waiver in part. And that one was deciding which court was going to decide the waiver of jurisdiction that went first. Because let's say Michigan decided not to waive that child to the other state, then the other state was going to do its own separate hearing dealing with whether or not their child should be waived up to Michigan.
Right. And did it get decided that they were going to be in the same state for purposes of jurisdiction?
So,
okay.
Yeah, so this particular
Gratefully.
one, the Michigan court ended up waiving to the other state's court.
Okay.
And then they handled both.
Okay. I wanted to touch on modifying a custody order and what it means for a state to have exclusive continuing jurisdiction, and that whole topic.
So, all right. So once a court issues a custody order, and so you're aware, a custody order is defined as any order that deals with custody or parenting time. So if it deals with either.
But not an acknowledgement of parentage,
Yes.
which is not an order, right?
But
Okay.
here's the complicated part is, so let's say you have a paternity case in there. Paternity is actually governed by UISTA regarding jurisdiction. So if you have a paternity case, if in that paternity case, you also ask for custody, that can make it into both. It can make it governed by UCCJ and UISTA if you are pleading the issue of custody as well. But if you're bringing just a pure paternity case, that would not be enough to have UCCJEA jurisdiction in there as well.
And the Paternity Act does not require custody and parenting time to be decided. It's just, it's permissive, right? So somebody could run a different case.
Interestingly enough, if you actually read the part of the statute that talks about entering the judgment of paternity, it actually says in there the court shall issue a ruling on custody if both parents are in an agreement. If they are not, the court shall issue a temporary custody and parenting time order pending further determination on the matter. So I don't think that issue was argued when it originally went on appeal on the two cases that dealt with paternity being a separate part, because that's not the way our statute, but the original jurisdiction part of the statute, that's not there. It's in the entry of the judgment of paternity section that talks about the court entering the order there.
So if the original custody order occurs in Michigan,
Yep.
Michigan retains exclusive continuing jurisdiction,
Mhm.
as
Yep.
long as a parent, not even the child, but just a parent still lives here, correct?
Yep, so as long as a parent still lives here, Michigan retains continuing exclusive jurisdiction over the kids. Interestingly enough, there's no provision of the UCCJA where the word transfer is used anywhere throughout it. It all comes down to whether or not a place continues to have jurisdiction, and then whether a new place has jurisdiction to enter its own order there. So for example, let's say Michigan issues a custody order and all the parents move out and they all move to the same state.
Nobody lives in Michigan.
Yep.
Right.
In that
Okay.
circumstance, no one lives in Michigan. All parties move to Ohio. Ohio would be permitted to modify the Michigan's custody order without having to have anything from Michigan authorizing that.
So you would have to file an initial, start a custody case in Ohio, but it's actually a modification request.
Yep, so
instead of
there's two
initiate,
different
okay.
ways that are fairly typical to go about the actual practical side of modifying. So let's say reverse it. So let's say Ohio issues its custody order. Everyone for this example lives in Michigan. Here, there's really two ways that are proper to do so. You could file actually a whole new custody case and just note the existence of it, and you probably attach it as an exhibit to the original complaint, the Ohio State one.
Mhm.
I, however, typically will register the out-of-state order under Article 3 of the UCCJEA. So I'll register it here, there. That way I get all the prior pleadings in the Michigan court, and then I file a motion to modify after I've registered it there.
Oh, interesting. Okay. I wanted to just one more question about the situation where there's a parent that's still living in Michigan, the other parent and child have left. We had a conversation about what does it take to have a quote unquote significant connection with Michigan.
The right now, both Michigan and most other states, the majority rule is if the parent that remains in the state that issued the custody order, there'll still be a substantial connection if that parent exercises some parenting time with that child in this state. The examples have generally been 1 day a year is probably enough to still have a significant connection.
Is there
may be forum nonconvenience and other arguments.
Right. Is there a case that has addressed that topic of
Yes,
how much parenting time it takes?
The published case in Michigan on that is White versus Harrison.
Oh,
White.
okay, got it. I'll put the site in the chat. Okay, let's talk then about the contrary. Okay, so child has 1 day of parenting time in Michigan a year. Okay, Michigan still has jurisdiction under, is it significant or substantial connections? Significant, isn't it? There's the term, there's a lot of different terms.
202 governs it. That's the threshold or the standard there, talking about continuing exclusive jurisdictions in 202. And
okay,
significant connection. But here, to be honest, usually if you're going to bring a motion in Michigan to waive to the other state, I would suggest doubling up. So bring it to waive jurisdiction or 202(1)(a), but then also bring it under forum nonconvenience. To be honest, you're probably more likely to win under the forum nonconvenience part of it, given if the parent here is only exercising 1 day a year or something, it's probably not the best forum. However, it could be, because if
that's 2071.
Yeah, 207. Yeah.
Okay.
But you may get backfired, particularly if you're arguing that parent remaining here is a bad parent. The evidence regarding that may very well be in this state.
Got it. So there was a question about whether there's a requirement to return the child to Michigan on issuance of the initial order.
There is not. There absolutely is not. It's going to, whatever court has the authority to issue the initial custody order, it can make that determination, but that's done in the best interest of the child. It does not have to order the child returned back to the state. But however, if it's a Hague case, that is a different story under the Hague.
Right, because that's a return. That's the whole action, is to return the child to the state of the country of habitual residence. Whereas UCCJ is about who gets to decide custody. Doesn't mean that the children have to actually be here, right?
Yes.
Okay.
And even under the Hague, it does not actually even under the Hague, it does not determine custody.
Right.
So generally under the Hague, it orders the parent who has the child to bring the child back to their country, but it does not generally deal with the possession of the child once there. Once there, it's for the other state of the other country to determine it. So if you do get a Hague, get your clients to go get a custody case going in that country, because you'll need to have some sort of interim order existing there for when the child gets back.
Got it. Oh my gosh, this has been so helpful, Matt. We're about to wrap up. If anybody else has a last question, we're happy to entertain it. But we are at the top of the hour. So I don't know, Matt, if you have any closing tips or points, or I think we covered most of the items that we wanted to touch base on. But if you think we missed something that you want to make sure you highlighted for our audience.
Yes. So just the key things to remember. One thing we didn't talk about is just because you register a case under the UCJEA or you modify a case here does not mean that it moves all aspects of the case. There are 3 parts to any case. So especially if a divorce case, you have the authority over the property parts, you have the authority over support, and you have authority over custody. Each one is a different type of registration. You have the Uniform Foreign Judgment Acts if you're trying to enforce a out-of-state property parts. You have USSA if you're trying to deal with the child support side of it, and then you have the UCJEA on the custody side. And all 3 are different registrations.
Got it. It's not complicated at all. And thank you, Matt, so much. And just so everybody knows, Matt, I think does practice all over the state. I'm guessing that you've come on as co-counsel to help out attorneys who might discover that they're in the middle of an interstate battle that they weren't necessarily ready to mount, and that you sometimes come on to help attorneys with in that regard too, not just handling the whole case yourself. Is that true?
And to be honest, usually if they're more than one county away of Kent, I usually require them to get co-counsel in the other county. So
Got
it's
it.
much easier working with someone that way than it is going into a county I'm not familiar with.
For sure, for sure. Well, thank you, Matt, so much for your time today. We really appreciate it. It's been super helpful. And as normal, we'll be putting together some takeaways, which will include these case sites and statutory sites for everybody who joined us today and for the people who signed up and who couldn't make it either at last minute. So thank you again, and you have a great day.
Thank you.